First of all, what are the unions? The unions are an association of people whose objective is to defend the social, economic, and professional rights and interests of its members. Many people in their group are only studying the laws and for their adherents to find the flaws or any contradiction with the practices of the organization. They can defend their interests in course with the justice system. The unions appeared with the law Welbeck-Rousseau, who was installed in 1884 in France. It is the first law to authorize the unions. Already in 1881 there were 5,000 union chambers in France, because they weren't forced to have any authorization from the government. They must, however, have as their exclusive objective the study and defense of economic, industrial, commercial, and agricultural interests. There are 10 articles in this law. The main ones are the second one, the fifth one, and the sixth one. There are several steps before an organization can be unionized. For an organization to get unionized, the majority of its workers needs to approve the change. It starts with a contract from an employee to a union organization, then a first meeting is organized. An intern committee is formed and the rules are accepted by the Workers' Party, so a certificate is delivered by the union. It includes the voluntary recognition, which is the proof that the majority of the employees accepted the adhesion, the basic certification. The pre-hearing vote is the general informational processes and contract negotiation, and finally the decertification, which is if ever the contract has to end because a staff member did not follow the rules or other reasons. If it happens, then the final step is to start the negotiation. Grievances are the same as a complaint. It comes from a dissatisfaction from either an employee or the union itself. In some cases, it can be initiated by the employer to an employee if the worker did not respect the rules, for example. It can affect every worker or only one. Grievances appear when the collective agreement is violated. Then a formal process sets up and actions need to be taken. The collective agreement is a special type of commercial agreement, usually as one negotiated collectively between management on behalf of the employee and trade unions on behalf of employees. The collective agreement regulates the terms and conditions of workers on their workplace, their duties, and the duties of the employer. It is commonly the result of a process of collective bargaining between an employer or trade union representing the workers. The arbitration occurs when the grievances cannot be resolved by both parties. It is performed by someone who is not involved in the conflict and who doesn't have any favorite party. The parties must accept that the decision of the arbitrator, even if they do not agree, is the final judgment. There are many advantages to be unionized. The unions must defend the employee's right by confronting the employer. Every employer must follow the laws, but sometimes some try to circumvent it because it is less expensive. Although sometimes it puts the life of the workers in danger or they are doing too much work. It is why they ask to be unionized. The idea of union comes from a dissatisfaction. Employees have more chances to obtain what they want with the unions because they are more powerful. Unions also fight to get more benefits to employees, like higher salary, health insurance, paid vacation, or others. Therefore, they control advantages like the health insurance, family allowances, compensation for the unemployed person, and also the pension for retirement, because they establish the rules and conventions. They can improve the status of the social concerns of a worker. There are also some disadvantages. On the other hand, employees have fees to pay to be unionized, and they are relatively expensive. Also, unions are talking for them, even if they have never experienced the real conditions. Workers cannot defend themselves. The employees are forced to do what the union asks them. If they ask them, for example, to do a strike, even if they do not want to, they must do it. Afterwards, the employer knows who was the leader of this movement, and probably he does not appreciate it. So even if he should not, he could discriminate the one who raised this idea or make reprisal and this afraid the employees. The employer does not get any benefits of being unionized. They are almost all negative. They are losing the absolute control over their organization. They have restrictions with how they are behaving and with the actions that they are taking. They must agree with every law, otherwise they will have big problems. It is more challenging for them when they are dealing with the complaints from a worker because they need to take action soon. The negotiation procedure. Data and facts are collected to create solid arguments for future argumentation. A comparison is made with the benefits of the employee that the employee already has and the salary they get. Instead of benefits, it can be the conditions they are working in a parallel in and a parallel can be made with other organizations of the same size. A close examination is made of the grievances. It needs to be realistic and favorable. It needs to bring important challenges in the business, and many employees should be affected by the changes. The unions can refer to previous cases for many reasons: to see how they end up, to have a better argumentation, to avoid doing the same mistake, to know what the court will answer, or only to have a better understanding of how the ceremony will take place. The unions must establish the strategies that they will use to convince the court. They will achieve this by setting clear objectives, knowing if they are ready to take a strike or a lockout, knowing how far they will push their arguments. The tone of voice is really important. During the negotiation, they must always relate to their main interests, but try to find a collective conclusion. The collective bargaining is a collective. Uh, Both parties have few advantages. For unions, they have the power to bring striking facts in court to persuade them, like working conditions, the laws that the company is not following, impressive sounding images, or others. They can rise a strike from manifestation because it is written in the contract, and it is not what the employer wants because his organization will not be working while its employees are in the street, so he will lose money. Also, if the employer definitely doesn't want any changes and he is completely closed to any suggestion, it happens that the union can fire him. For the employers, because the business continues to operate, many employees do not have the time to speak to the unions and they are not present during the court. Also, he can decide to close his company for a certain amount of days, but the workers are not paid, and this is not what the unions want because the employees will not be satisfied. News. Uh, the service of ambulances who serves Montreal and Laval asked the tribunal to have replicants during the absence of certain people. They needed the unions to obtain this simple request. They began a strike February 5th, and they obtained what they wanted on April 7th. The court finally accepted the offer made by the unions because they judged it simple and without ambiguity. Therefore, simple to implement. The unions will receive a legal notice to implement their actions, and then they will be able to start their plan to fill the unoccupied jobs during absences. It is important to mention that the service of ambulances is extremely important for the general population, and there should never be someone missing because it needs to be effective to save lives. Unions are present in our lives, and they occupy an important role. Except from the unions, employees have other rights and privileges. The employers must treat every employee equally. In an organization, there is no place for discrimination or favoritism. He must keep the employee's personal information confidential. He cannot use this information against him. The employer must provide a safe workplace for its workers. A reasonable care or attention is required. Otherwise, the employer could receive consequences like being held negligent if he does not follow their specific rules. Also, the employers have job expectancy rights. The employees' benefits are beneficial, therefore they have some restrictions to comply with. They cannot do drugs while they are working. Before and during their working hours, they can have tests or alcohol tests. They can have drug or alcohol tests. Also, the employer can access the employee's file, the employer can access the employee's file, but he has to respect the worker's electronic privacy. Employees must conduct well outside of the office because their reputation can affect the company they're working for. So even if they are in vacation, they need to have good manners and respect the rules of etiquette. If If the employees do not want to submit themselves to these rules, then disciplinary policies and procedure will be applied. It is important that the required behaviors from the workers are clear and effective. The policies, if someone breaks the rule, must be explained to everyone, just like the behavioral standards. It is the immediate supervisor who is in charge of punishing the bad actions. Before to do anything, he needs justifiable reasons. Discipline objective is to strengthen the desirable conduct and develops control in the organization. The most frequent disciplinary problems are attendance problems. For example, an employee has unexcused tardiness, or is leaving without permission. Also, dishonesty problems, like if a worker falsifies his application or punches someone else's card. Work performance problem is like when someone fails to establish the production requirements or fails to complete the work assignments. There are also behavioral problems. For example, if some people fight or do not report their injuries, or they're basically sleeping at the job.